the ideas that we asked the members to consider. And the essence of it is that, in summary sort of sense, is that this creates a different, very different method of creating an arrangement, a relationship and an arrangement with professional staff and school boards. And what I'd like to do is just review the sections that we have. Yes, sir.
Mr. Chairman, before we get started on going through this, and I'll note that I received this when I walked into the room, and I'm on about page 7 of 20, and I certainly would like to make sure that I get through the whole thing, reading it myself before we talk about it. But I would move you, sir, that we move this meeting to LP 12 or some area down in the Capitol where we can throw on the video. There's been no bill that has been talked about, discussed, debated more than Senate Bill 113. For everybody's sake, we should have a thorough vetting of how we come to this conclusion before we go back to our bodies and discuss what conclusion we came to. People have a right to see it. They have a right to see what we did in this room, not just today, but in the future when they look back and talk about this. And so I don't care what room it is. I don't think it's going to make a difference in the ultimate outcome, but it sure makes a difference in how we appear to the public and to the teachers who are concerned about this bill as we come to the resolution of what the conference committee compromise is.
We're going to continue the discussion here. If anyone would like to, continue the discussion, individually with their caucus or with a group, you feel free to do that. There's nothing problem there. But this is a media event. There are folks here that can record and review all that we say and do, and that's where we're going to proceed. We're going to go this initial review right now. Well, I'd like to do is to review this, and if you want to follow along, we'll be working through the process that you have in the document that you've been given.
Mr. Chairman, I'm sorry to interrupt. I just want to make sure before we get started on reviewing this, that if we need to vote on it, we vote on my motion. But I don't believe this is a media event. I believe it's a public event. And my problem is that the people in here are media.
The public is here, Senator. We're going to begin with the review and go from there, okay? So if you want to follow along.
Is there going to be a vote on my motion?
I think our task is to determine a conference report on this item, and that's our task.
So there's not going to be a vote on my motion?
That's correct. First item from the standpoint of concept that this is titled is...
I'd like a ruling, parliamentary ruling as to whether or not that's a proper...
We have an attorney here.
You have to call for the vote on parliamentary.
That's a clerk.
Mr. Chairman, go ahead and call for the vote. It is.
All right, let's call for the vote. All those in favor of this motion say aye.
Aye.
All those opposed?
No.
No. Motion fails. We're back on this discussion. The title that we're looking at is changed to the Professional Educators Collaborative Conferencing Act of 2011. And it's very clear in the language that it includes this aspirational language regarding open, trusting relationships and collaborative problem solving. The essence of what we're trying to do is to go from a combative concept that is inherent to collective bargaining, which is a positional approach. We're going to go to a problem solving and issue-based approach. That's very important, very critical. Third item, it requires training and collaborative problem solving to develop the Tennessee organization school superintendents by January 1st, 2012, and to be implemented with each local education agency by July 1, 2012. At that point, we suspend all negotiations under the Education Professional Act. This statute prohibits collaborative conferencing until the training has been developed and implemented. And we've conferred with the folks at TOS, and they are willing and interested in doing this. They want to be an active partner in this vein. There are a number of school systems today that do collaborative methodology. This is not an alien methodology to some school systems. The definition section defines Board of Education, collaborative conferencing, management, personnel, management team, memorandum of understanding, person, professional employee organization, representative, strike, supervisor, working condition. and political activity. Two or three concepts that are there that are important to note, that the principals and assistant principals in that particular group are considered part of the management or considered part of the administrative aspect, where in the past they were considered part of as a professional employee in reference to the negotiations. The sections 603 and 604, it explains the rights of professional employees and the preservation of these rights. And it also deletes provisions regarding recognition of exclusive representation and decertification of exclusive representative. Ensures that teachers are engaged in collaborative conferencing with the Board of Education through representatives by professional employee organizations and or by unaffiliated status. This explains the process by which that is done. The selection of those panels for the professional employees is basically a process where all the teachers would be asked to vote, yea or nay, do you want to be involved in this kind of activity? You then have a second question. If the answer is yes, then you would be asked the question, who would you like to be your representative in the sense of organization, or you have a choice to say unaffiliated. So you can choose whomever and however you want to vote in that manner. If you choose to select no, then you're asked the question as well, saying, if this were to occur, do you have a preference? And that same set of responses are available. And also, the unaffiliated are included. This is also a statement, none of the above. In other words, if a person doesn't want to be involved in any form or fashion, then they have that option to maintain that philosophy on their career. Let's see, it clarifies the process by which collaboration shall take place. There is a special question committee that's set up to begin and to conduct this puzzle, to run this kind of an election, and that's their purpose in that vein. And it adds new provisions regarding the method of selecting, as we mentioned before, representatives, professional employees, through this ballot. Proportional representation. In other words, as you read the results, it's set up that the panel would be proportional in reference to the desires of the teachers. So you have, mathematically, if you reach a threshold of 15% of any category, that tends to create a person on the panel. That will create a person on the panel. And there, at that point, though, that begins the evaluation and determining proportional. If you have 2/3 that choose to be representative of TEA, that can be done, and that will be done. And then the other third would be the other categories that the employees so request from that standpoint.
If the three categories mean what again?
Three categories.
What if it's unaffiliated?
Then there's a process set up in this language to provide a way for the unaffiliated folks to be on the panel.
What's the process?
The process is that committee that set this process up, that would run it, will be involved in developing a method and setting up a way that all those unaffiliated would select and or they would appoint to get it started. So the unaffiliated would find a methodology.
So are you talking about TOS is going to set up the process?
No. This special questions committee.
And what section are we in?
That is section
Page 8.
Page
it's on
8.
page 8.
I haven't gotten there and reading it yet. Okay.
Yeah. It starts on if you're looking at little a on page 7, under 49.5605 representatives, that's where it begins that review and that particular approach. And then it goes through B, and it talks about the B. It's set up in regard to the size. The folks would determine anywhere from 7 to 11 as to the size of the representative panel. It's the professional employees panel of 7, or it would be the board panel of 7, but it could be as high as 11. And mathematically, 15% just pretty much requires a panel of 7, because if you have 6 entities, you're a little less than 100, but if you were to have 7 entities, you'd be over. So we chose the panel based on the mathematics. as well as a variety in selections that we do from that standpoint. That explains, and you get into page 8, it talks about the issues of that particular vote, as we just had previously explained. Okay. Let's see. Says here again. Let's see, it also has explanation in 609 of unlawful acts, the refusal or failure to participate in the collaborative conferencing. It retains provisions of filing complaints in Chancery Court where an LEA is located, but shortens the deadline for filing the complaint from 6 months to 3 months. It retains a no strike provision. It retains the concepts that are found in 611, all of those except disciplinary actions. And it basically includes all that which we are currently, looking at as a scope of discussion, and currently as a collective bargaining concept. There are a number of items that are prohibited in regard to the collaborative discussions. And let me go over that. These are the concepts that we have reviewed on many other documents before. Differential pay plans and incentive compensation, expenditures of grants or awards from federal, state, or local government and foundations from private organizations that are expressly designated for specific purposes, evaluation of professional employees, staffing decisions and board policies related to innovative educational programs, personnel decisions concerning assignment of personnel employees, including the filling of vacancies, the assignments, and the duties, and so on and so forth. That's in the current code. And it also mentioned at this point, there's discussion about the fact that what is also prohibited, and this came from some conversation with a number of members, that what is also prohibited, payroll withholding, is very much included, except for any kind of activity that would create dollars that go to tax. So you're pulling out any kinds of dollars collected that is not a part of the negotiation, that we wind up with a political arena. Insurance, dues.
We'll have 16.
16?
Has this previously been a part of any of the bills that were adopted by either version of the House?
No, because payroll deduction was not included in earlier votes.
Why are we doing something now that we didn't do in either one of the bills?
We felt like payroll deductions was worthy of discussion, except for political purposes. Our members in the House wanted payroll deductions included. There was a very clear message in the House.
So this.
We talked about that at great length. We want payroll deductions.
Who is the we?
In the House of Representatives.
No,
Was Speaker DeBerry or any Democrat included in that discussion?
We on the floor discussed the issue of payroll deductions. We asked, the membership asked to include that. That is included.
I just want to be clear about who the membership is.
The membership of the House of Representatives, the 99 folks that have been discussing the bill at various times.
And we talked about it for 5 hours yesterday on the House floor. This bill.
That was an item that the membership, requested that we include, and we have included that. That's a result of the membership's request. So are a lot of these ideas in the House. I did not listen to the Senate debate, but the House debate wanted these provisions.
What does it do with regard to payroll deductions?
It's an item that can be collaborated on, except for any kind of monies that are going to wind up in a political activity or a political purpose. Dues, membership, insurance, it doesn't matter.
And was this brought up because of previous contributions that were made by the Tennessee Educators Association?
In the discussion I had, no one brought it up in that manner, but this is in response to the request from the House members.
I just find
That's where we are.
I just find it interesting that that the accusation is that people fought back on was that this was political payback, and now we have a provision in here that takes out their ability to engage in political activity which was never in either one of the versions that were adopted by a chamber of this legislature.
Do you want us to exclude payroll withholding as a deduction, as a collaborative idea?
I want you to exclude it as a collaborative idea and make sure that we don't prohibit them from engaging in the same activities that many other organizations engage in.
It's fine. There's nothing prohibited about the engagement. They just have to write another check. There's no activity that says you can't do it. You just can't do payroll withholding to collect money that winds up in a PAC.
I understand that.
So, but that can be done. This is not prohibited by fact. It is prohibited in regard to payroll withholding for political activity. There were many of our members that expressed on the floor, both sides of the aisle, they don't want the folks to be involved in political activity. So,
On both, which folks on
in the House of Representatives.
I know, I'm saying which folks on the Democratic side of the aisle expressed
It was
some
part of the
dissatisfaction.
discussion and comments that were made, but
I didn't watch the entire debate, but I certainly didn't hear that. It seems to me like we are singling out one group of people to say that they can't have payroll deduction
no, that's not
because
what we're doing. Let me explain again.
I understand
We
what
were permitting, you just then said, we're not having payroll deduction. We are. Let's make sure it's clear. We are permitting payroll deduction collaboration. We are not permitting. So be clear about the language you use, because so many people out there will hear that comment and say, we're going to exclude all the discussion about payroll withholding. That's not correct.
we're going to say it can't be used for political activity.
We cannot withhold stuff for political activity. That's simple stuff. Okay. Okay. All right.
I understand.
Moving on. Requires that no agreement shall include provisions that require personnel decisions to be determined on the basis of tenure, seniority, and length of service. Allows for free-flowing communication between the director of schools and professional employees employed by the local board of education. Provides for a memorandum of understanding. Parties to jointly prepare a memorandum with matters agreed upon. Term of agreement to be no more than 3 years in regard to the panels that are representing the professional employees. And the terms requiring the Board of Education as an item on the agenda or on a regular special call board meeting or at a later effective date that is explicitly stated in the memorandum. Makes code consistent with this act, providing nothing in the act shall be construed to impair already existing contracts under EPNA until such contracts expire, at which time the act shall take effect, and that provides a severability clause. The essence is that this proposal says we've been dealing with, in this state, a positional combative approach. This bill, this proposal says, let's start solving problems in a collaborative manner. That's where we have input from the folks that are involved in this. Of the folks that I have talked to individually, the letters that I've read, that's their concern. That is the House's concept as well, within the language that we have addressed. So I'm suggesting, and this document suggests, that there's a better way to accomplish what we need to accomplish in education outside the scope of the term collective bargaining.
Mr. Chairman, I would ask that you allow, I know that 4 members of this conference committee have seen and been discussing this particular language. It's a 20-some-odd page, 20-page report. I would ask that you give Speaker DeBerry and I 10 minutes to read this, make any suggestions that we can, and come back and discuss it.
Let's take, can we do it in 5 or you want 10?
10. Let me
Okay.
take 10 minutes.
And I say, Mr. Chairman, as long as we stick to 10 minutes on the nose, we'll
Okay.
distribute a conference committee.
Well, what
report.
time is it now?
I've got 17 after.
It's 17 after, at 27 after, we will reconvene. Okay?
Thank you.
I didn't ask. I didn't ask you any other comments. Board of Education, as an item on the agenda or on a regular special call board meeting or at a later effective date that is explicitly stated in the memorandum. Makes code consistent with this act, providing nothing in the act shall be construed to impair already existing contracts under EPNA until such contracts expire, at which time the act shall take effect, and that provides a severability clause. The essence is that this proposal says we've been dealing with, in this state, a positional combative approach. This bill, this proposal says, let's start solving problems in a collaborative manner. That's where we have input from the folks that are involved in this. Of the folks that I have talked to individually, the letters that I've read, that's their concern. That is the House's concept as well, within the language that we have addressed. So I'm suggesting, and this document suggests, that there's a better way to accomplish what we need to accomplish in education outside the scope of the term collective bargaining.
Mr. Chairman, I would ask that you, I know that 4 members of this conference committee have seen and been discussing this particular language. It's a 20-some-odd page, 20-page report. I would ask that you give Speaker DeBerry and I, or 8 versions that we've had of this bill. This, in fact, has been the most confrontational policy decision that I've seen in my 4 years up here. And for us to be talking about getting rid of confrontation in the most divisive debate that I've seen is true irony. To add, after all that we have been through, additional provisions that restrict the use of payroll deductions for political activity indicates that the true nature of what we're doing here is not at all about kids, not at all about education, but about politics. That's a shame. We are at our best when we work together in true collaborative fashion, as this word says, to come up with the best solutions that we can for Tennessee kids. That's what we did in terms of the Complete College Tennessee Act, which you and I worked on together, in terms of the First at the Top, which you and I worked on together, and on many of the other ideas that have held education reform in Tennessee. This is not one of them. And in fact, I think that this version, as I've said about every version, may make matters even worse than the one before. That's a shame. And Tennessee teachers are not going to be pleased to be excluded from the process. We should not have had this committee in this room. We should not have received this language after we walked in and y'all had it for the whole time. We should be out there trying to find a solution to these issues that truly brings people together instead of setting us apart. We should be looking for education solutions that work on the classroom and not on politics. This particular conference report does none of those things, and I'll be voting no.
Other comments? Senator?
Mr. Chairman, I just, again, you brought something up earlier that some people seem to think that if they say it enough, it'll be true. And to say that we are attempting in any way to exclude teachers when this bill does the exact opposite. The reason we're here, Mr. Chairman, as most members know, is because our current system is broken. As you stated very eloquently, it's created an atmosphere of confrontation, litigation. The Educational Profession Negotiations Act has been a little more than an avenue for our school boards and our union, teachers unions at the local level to end up in court. And we can cite cases from one side of the state to the other that represent that. That's not a collaborative relationship. It may work in some districts, but our school board association, our county commissioners association have asked us as a General Assembly to try to fix this. And I think this conference report, with input from many members of the General Assembly, does just that and will foster a collaborative, non-confrontational relationship between our teachers and our school boards, which is what we want. As I've stated repeatedly, It is the height of hypocrisy for this General Assembly to require collective bargaining at the local level and not require it of itself, which is exactly what the Negotiations Act does. This will put our local school boards in a posture much like we are here in the General Assembly, where we take input from our teachers, we listen to their concerns, and we make the best decisions we can. And we should trust our local school boards to do the very same thing, just as we do up here. And with that, I move the previous question.
Question's been moved.
Second.
Second. All those in favor of the position, vote aye.
Aye.
What?
Putting the question.
Sure. And as serving as the chairman of the Senate portion of the conference committee, I'll call
Put
the
this to
roll.
the Senate members.
Okay. The motion is to put the previous question.
Aye.
Oh, well,
Senate members are
I
asked
don't
to
know if
vote.
there, I don't know if we're, is there objection to the question?
Okay.
That's what I was trying to find out from.
Okay,
Speaker
I'm
Bell,
sorry,
whether
Speaker
she wanted
DeBerry,
to talk.
was there objection to the question?
Well,
I
there,
ask if,
yeah, I mean, let me say, I've been here long, probably anyone in this room. This is the first time that I've ever sat on the conference committee report. When you walk in and they give you the actual conference report. I thought you take both reports and you look at it and you see if you can make the bill better. We've not been given that opportunity. And I just feel like if I feel violated, then I know that the teachers out there are gonna feel violated. And I just think this is a bad way to do business. I mean, anything that we would have come up with, you had the votes to do it, but this is not a fair process. It is not a fair process. And I just really want to say I'm shocked and I'm appalled because I know all of you here and I have a lot of respect for you, but you know in your heart this is not the right way to do this.
further comments? Proposal before us, I think we have to vote Senate and House separate. Let's take the Senate first. The proposal is before the Senate. Members?
Senate side, objection to the question?
None.
Okay. Senator Burke?
No.
Senator Gresham?
Yes.
Senator Johnson, aye. 2 ayes, 1 no. The motion passes.
Representative Maggart, let me let you manage the House side.
Is there an objection to the question? All those in favor say aye.
Aye.
Representative Brooks, aye. I vote aye.
No.
Representative Berry votes no.
Vote is 2 to 1 in favor of. So the recommendation coming out of the conference report is to recommend this to the House and to the Senate. And at that point, there will be lengthy discussion, I'm sure, in the House and the Senate in reference to these ideas and these issues. Any other items come before this committee?
Helen, on the conference report, you just need the signatures of those affirmative? Okay.
You guys know who's going to take it up first, House or Senate yet?
Senate
Senate.
has to.